Good afternoon and welcome to the webinar on the fundamental right to reservations. We've been hearing a number of statements in the media that our right to reservations is not a fundamental right. This seminar comes together to very clearly and unequivocally send a message that we do not agree with this view, that we believe that the right to reservations under the Constitution is a fundamental right, and we will explain why, and we will do so in one part today on the larger questions involved in this debate, and including the very, very serious risks that come from such a statement, as well as looking at the architecture of the right to equality, the right to reservations, and also looking at the historical background in which the right to reservations emerged from the Constituent Assembly. I intend to address these two aspects, which will be followed by another webinar where we will go into some technical detail about the particular judgments of the Supreme Court, recent as well as older judgments, which seem to take the view, which actually take the view that there is no fundamental right to reservations. And we will analyze the law laid down by the Supreme Court in those judgments, and we will argue that that law is wrongly laid down based on a very limited understanding of the provisions concerned and their historical background and their true nature. So that will be in a separate exercise. Now, as we get into the substance of the argument that I'd like to make today, I'd like to begin with the first part, namely the larger risks involved in the proposition that reservations are not a fundamental right. The larger risks come from the fact that the fundamental right to reservation is a fundamental right because it is set out in Part 3 of the Constitution. Part 3 of the Constitution has the title Fundamental Rights. So one would think that everything that is in Part 3 is a fundamental right. Every right conferred by Part 3 of the Constitution is a fundamental right. And so now if the judiciary argues that a part of Part 3 of the Constitution, one provision in this Part 3 of the Constitution, because of its wording to which we will come, is not really a right, and therefore it is not a fundamental right. Now we are entering very dangerous territory, because if it was not a fundamental right, then why would the Constituent Assembly put this provision under the fundamental rights? In fact, as a matter of fact, jumping a little ahead because I'll come back to the Constituent Assembly debate later, in the Constituent Assembly, one member at one point did suggest that the right to reservation should not be part of the fundamental rights, and that view was rejected. Not only was that view rejected, but speaking in his capacity in the Constituent Assembly as chairman of the drafting committee, Dr. B.R. Ambedkar explicitly referred to the right set out in Article 16(4), reservations for backward classes, as a fundamental right. So the proposition that right to reservation should not be a fundamental right and therefore should not be part of Part 3 was made, showing that if it was included in Part 3, it would be a fundamental right. And second, the chairman of the drafting committee and the entire Constituent Assembly endorsed the view that right to reservation should remain in Part 3 as a part of the fundamental rights. And so it has been included in Part 3, and therefore the first point to make is that we have to accept that all elements that constitute Part 3 of the Constitution are fundamental rights. read in one way or another. And if not, we're going back to the old A.K. Gopalan situation where we are reading rights in Part 3 as narrow silos that exist in isolation from each other and can be interpreted in isolation. And we are moving away from the broad jurisprudential concept that fundamental rights, which are by their nature human rights, are indivisible and non-derogable, and they should be read together and not taken apart piece by piece. And therefore, the whole proposition that the right to reservation is not a fundamental right is a very dangerous proposition, because once this proposition is accepted, that you can read a few words in one part of Part 3 in isolation and say, yes, it is in Part 3, but it is not a fundamental right. If that approach is extended to Article 21, we may find that our right to life and personal liberty is taken away from us. If it is extended to Article 14, we may find that the right to equality is taken away from us, which is partly sought to be done by the argument that right to reservations is not a fundamental right. And we may find that other fundamental rights, such as Article 19, the right to freedom, and Article 25, the right to religion, can also be either reduced or taken away by an interpretation of the wording of those clauses. So protecting the integrity of the concept that any right in any part of this constitution is a fundamental of this part is a fundamental right and should not be taken away, I think is very vital. Now, if someone has the view that the right to reservation should not be a fundamental right, what should they do? This is not a matter for a bench of 2 or 3 or 5 or 10 or 15 or 30 judges to decide. There are 31 judges, including the Chief Justice. It's a small number compared to the hundreds of parliamentarians and state legislators who will have to be involved in any amendment of the Constitution of this nature. So if they want to remove a provision in Part 3, because they believe, some people believe that it is not a fundamental right, then the appropriate course of action is to take this to Parliament and have Parliament amend the Constitution, as we did in the case of the fundamental right to property, and remove the right to reservation from the Fundamental Rights chapter, put it in some other part of the Constitution, or even remove it altogether if that's what they want to do. But that still is going to run into a problem. And that problem is that after Keshavanand Bharati, according to the Supreme Court, even an amendment of the Constitution has to be tested against the doctrine of basic structure. In other words, the legislature does not have the power to amend the Constitution in such a manner that it derogates from the basic structure or violates the basic structure of the Constitution. Now, in this particular case, we know that the right to equality is one of the core elements, has been accepted as one of the core elements of the basic structure of the Constitution. And if you are going to take away one of the most important elements of the section of the Constitution on the right to equality in Part 3, which consists of Article 14, 15, 16, 17 and 18, clearly that will derogate from the right to equality, which is a part of the basic structure and therefore would not be valid, which means that even Parliament does not have the power to remove something from the right to equality under the Fundamental Rights chapter, Fundamental Rights Part 3 of the Constitution. And if the legislature does not have the power to derogate from the basic structure, certainly the judiciary, as a guardian of this basic structure, lacks that power as well. So there is no judicial competence, there is no legislative competence to take the view that the right to reservation is not a fundamental right, because it is part of Part 3, which has the title of fundamental rights, and everything in this Part 3 is a fundamental right. They are all interrelated, indivisible, interdependent, and therefore they cannot be tampered with either by the judiciary or by the legislature. They have to simply fulfill their duty to implement this right. Now, this is the first point about the huge dangers involved in this unconstitutional and illegal attempt to tamper with the integrity of Part 3 of the Constitution, which is the fundamental rights part of the Constitution, the heart and soul of the Constitution. And it is like, it's like attacking the heart of a human being. It will destroy the entire health of the person. Similarly, if you tamper with Part 3, the Constitution is going to be mortally wounded. The next part of my argument has to do with understanding the structure of the right to equality and the particular provisions in Article 16 for which are impugned as being not fundamental rights. Now, as I said earlier, there is a segment of Part 3 which has the subtitle given in the Constitution itself as the right to equality. It includes Article 14, equality before law, that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. It is Article 15 that deals with the very, very urgent and pervasive problem in our society of widespread discrimination. And so Article 15 says, prohibits discrimination on grounds of religion, race, caste, sex, or place of birth. And then it has some other provisions that I'm not getting into, more detailed provisions prohibiting discrimination. Article 16 deals with equality of opportunity in matters of public employment. I'll come back to that because that's the main topic of our discussion today. Article 17 abolishes untouchability, another huge social problem. And Article 18 abolishes the use of titles. Now, Article 16 is called Equality of Opportunity in Matters of Public Employment. And Article 16 has three important fundamental rights inside Article 16. That there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. And then it says, no citizen shall be discriminated against in respect of any employment or office under the state on grounds only of, and then it lists 7 grounds. It was 5 under 15, the common 5 between 15 and 16 are religion, race, caste, sex, and place of birth. But it adds 2 grounds, and those 2 grounds are, interestingly, descent. Discrimination based on descent, which is central to the idea of caste, because caste is it is a status that is inherited through descent. So it bans, in addition to saying caste, it talks about not only it talks about it talks about prohibiting discrimination on the basis of descent, and also in terms of place of residence. Again, given apartheid in our country and many rural and urban areas being segregated by caste and community in our country, the Constitution recognizes the reality of discrimination based on where you live and the address you give, and that again cannot be a source of discrimination. So what we understand here is the Constitution, like it is addressing untouchability, discrimination under Article 15, it is addressing a concern that a number of people could not get jobs in government because they were excluded from these jobs based on their caste, their religion, their race, their gender, descent, place of birth. And therefore, the government offices were restricted to a small number, generally of upper caste Hindus who monopolized public employment, and others were excluded. So Article 16 is actually a response to casteism and communalism and patriarchy and gender discrimination, where formerly people who are not Hindu upper caste male were often excluded and considered ineligible to hold public office. And it is that particular problem that is sought to be addressed in 16. When it says equality of opportunity in matters of public employment, there is no need for the Constitution to put a provision to promise equality to those who already had it. The only purpose of Article 16 is to defend the equality, secure and defend the equality of those who did not have equality, those who are subjected to inequality on these grounds and on other grounds, those who are excluded not as individuals but as members of their class simply because of the accident of their birth, as members of their community. So that is the problem that Article 16 seeks to address. As I said, there are three rights in Article 16. The first fundamental right is as I said, the right to equality of opportunity in matters of public employment to overcome what once was express and now becomes implicit and still is an implicit discrimination against those who are not Hindu upper caste and male, that they somehow are not good enough to occupy a government office. The second fundamental right that emerges, that is in Article 16, is the right of classes that are discriminated against to have adequate representation in services under the state. So again, as a matter of policy, we know of many instances where very highly qualified people like Mr. K.R. Narayanan, for example, where after he got a degree from the London School of Economics and a letter from Harold Lasky, when he came back to India, he was offered jobs that were not, very low-level positions in the government, and it was only because of the personal intervention of Jawaharlal Nehru that he was finally appointed to an appropriate position as a diplomat in the foreign service rather than to a clerical position. So we know that that all but upper caste Hindu males as a class were excluded from public employment, and therefore the classes to which they belonged, because of which they were discriminated against, were not represented in government service. And therefore the third principle is that every class that is not represented shall be adequately represented in public service. Now there is a small background to this which I will also mention. On August 27th, 1947, 12th day after India became independent, two Dalit members spoke at the Constituent Assembly, Mr. Muniswamy Pillai and Mr. Nagappa. And the two of them, both of them said, speaking separately but saying the same thing, that they are very worried, and what they said in exact words were, there is fear, said Mr. Muniswamy Pillai, there is fear in the minds of the oppressed classes that the Hindus have come back to power. Those days Hindu meant only upper caste Hindu. So while there was celebration for all of us that colonialism had ended and the struggle of the masses, the Avarna masses, had actually led to the British having to leave this country, as Muniswamy Pillai said, he said that there is fear in the minds of the oppressed classes that the Hindus are coming to power, and he asked, what will happen to the Harijans? Is Hindu Raj coming? He asked in explicit terms. Is Hindu Raj coming? And will we be forced back into Varnashrama Dharma again, which harasses the Harijans? Mr. Nagappa echoed this. He demanded that all sections of the Indian population must have their due share of employment and opportunities in education and in the legislature. So he said, we want our due share. He said, I may be illiterate, I may be dumb, but do not use my illiteracy or my being dumb against me to deprive me of my due share. I must have my due share, because that is my right. He basically said, recognize my equal humanity and give me my due share. Don't deny it on the basis of my lack of ability, which abilities he lacks, or the classes lack, because it was made illegal for them to acquire any such ability. And so he asked for a due share. He said, I don't want to, his words, I don't want to rob Peter to pay Paul. I want my due share and nothing more, because it would not be right to have anything more. So from this context, and then he made a very, very pregnant statement in which he said that, look, other communities have asked for partition and have got it. No one is more entitled to ask to claim another country than us, the aboriginal people of this country. But we want our due share. And what he was implying was, either give us our due share or partition this country again, so that we don't have to live under the hegemony of the Hindu upper caste, under Varnashrama Dharma, and be discriminated against. So it is against this background that which was very much in the air, explicitly stated by Mr. Muniswamy and Mr. Nagappa, that Article 16(4) of the Constitution creates the second right, the fundamental right, and that second fundamental right is the right to adequate representation of all classes. And that, of course, means, as Mr. Nagappa said, the due share that belongs to every class based on its population share. It should not be less, it should not be more. As he said, I don't want to rob Peter to pay Paul. I want due share for everyone. And if anyone has more than their due share, someone is going to not have their due share. So the right to adequate share also means the obligation, not the legal requirement that no one shall have more than their due share. Because if you have more than your due share, the others are not going to get their due share. In the context of this background, the second fundamental right that is in Article 16 is the right of every class to have its due share, no more or no less, approximately speaking. We're not talking about mathematical precision, but broadly speaking. It should not be like now that there is a vast gap in, for example, the representation of certain communities in the highest level of the state, and some other communities who are virtually unrepresented. So this is the second fundamental right. The third fundamental right is the fundamental right to reservations, which is in 16(4). And 16(4) says, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services under the state. Now, so the Constitution says there shall be equality of opportunity in matters of public employment. It says there shall be adequate representation, and then provides a clear constitutional mechanism to ensure that these rights are secured. And that mechanism is reservation of seats, of positions or seats, in favor of those who are not adequately represented because they do not have equality of opportunity. So this is one integral set of three rights, which are then connected back to Article 14, consistent with Article 15, because this argument applies equally to Article 15. It goes into Article 17 because those who are victims of untouchability are also discriminated against in education in Article 15, in employment in Article 16. And so we can see the interrelationship between these various rights. Now, it's interesting that those who are arguing that there is no fundamental right to reservation are relying on the words. It says, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in services under the state. But this language, nothing in this article shall prevent Parliament from making, is being used by those who are saying it is not a fundamental right to say this is only an enabling clause. This is not a right. And therefore, if there is no right, there is no fundamental right. The chair of the Constituent Assembly, actually with the permission of the Constituent Assembly, called first on a series of representatives from the Avarna communities, from the excluded communities, to first speak and express their point of view before allowing the members who came from privileged communities to speak, because it was very important to ensure that there was a consensus built, that there must be these provisions. There must compulsorily be these provisions that are intended to address social justice in our country. And one of these Constituent Assembly members who walked up to the podium referred to this: nothing in this article shall prevent the state from making any provision for the reservation of the appointment of appointments or posts in favor of any backward class of citizens with delight, because he read it in the context to say that there shall be no excuse for Parliament not to provide reservations. He did not read it as an enabling clause. On the other hand, he read it as an overriding clause, which said that there shall be no excuse that Parliament can invoke not to make laws providing for reservation. This is the manner in which a member of the Constituent Assembly actually read this provision, and that's what it really means. Everyone in the Constituent Assembly accepted that this is not an enabling clause. It is a clause intended to ensure that no other law shall prevent Parliament from ensuring that reservations are provided when there is no adequate representation in favor of for a particular class, of people. Now, so therefore, we can read nothing in this clause, nothing in this article shall prevent the state, either as being an enabling clause, which would be you have to read it completely out of context, or you can read it in context and understand that nothing in this article shall prevent the state from making a provision as saying that Parliament will not be able to invoke any excuse, that Parliament, absolutely nothing shall stop Parliament from making provisions for reservation in favor of a community or a class that is not adequately represented. And that is the intention with which it was provided. And that is why Ambedkar referred to Article 16.4 and said there was a lot of discussion on the word backward class, which I'm not getting into here. We will reserve it for the next session that looks at the law in detail, but which prompted Dr. Ambedkar to say that we have introduced the word backward into Article 16, into this fundamental right, referring to Article 16.4. So it was very clear that this was meant to be a fundamental right, both 3 and 4. Now, these fundamental rights under the law of obligations are obligations cast upon the state to act in prescribed circumstances. So it is like the discretion of the police, for example, to use force to protect law and order, to uphold law and order, to prevent somebody from being murdered. So let's say a policeman is standing there and somebody is trying to murder somebody else. And what we are saying is nothing shall prevent the police from taking necessary action to prevent a person from being murdered. What does that mean? Does it mean it's an enabling clause? Or does it mean it's an obligation imposed on the police that if somebody is going to be murdered, you shall take whatever action is necessary to ensure that the murder does not take place? Clearly the latter. Similarly, these are obligations placed on the state to be triggered by the occurrence of an event that is prohibited by the law or the constitution. Murder is prohibited, therefore, or crime is prohibited. Therefore, the police has an obligation saying nothing shall prevent the police from acting promptly and effectively if a crime is about to happen in the presence or is happening in the presence of the police officer. It doesn't mean that it's an enabling clause and the judge can say, okay, policeman, you saw a crime taking place in front of you. It's only an enabling clause, enabling power that you have. You don't need to do anything. If you wish to do it, you can. You have the power to do it, but you don't really need to do it. It's not an enabling clause. It is an obligation created on the state which will be triggered by the occurrence of an event that should not happen. Therefore, similarly, what the Constitution wants to to get rid of, to annihilate, to end is a situation where there is inadequate representation of any class of people in public employment. And when that situation exists, there is an obligation on the part of the government to intervene, and an absolute positive obligation that the government, nothing shall prevent the government from taking necessary action to put in place reservations to ensure that there is adequate representation for all classes, and that will then give equal opportunity to members of that class. And therefore, it is very clear that this language here is meant to cast an obligation, a mandatory obligation on the state to take necessary action when there is inadequate representation and of classes in employment. And we know that that is not a hypothetical situation. The starting point in the Constitution in 1950 is that there is massive inadequate representation. Even today there is massive inadequate representation. There's a lot of statistics on that which I'm not getting into. So the starting point is, we know that this is a problem, and therefore it's a curative measure to that problem. And that curative measure, because the prohibited state exists and we know that, then we have an obligation, that the state has an obligation to put in place reservations right away, not to wait for data, not to wait for to find out whether there is adequate representation or not, but to immediately act to address the lack of adequate reservation, which is what prompted these provisions in the first place. It is like saying that if someone has COVID, the medicine must be given. It is not an enabling sort of advice. If it was, it is an obligation on the part of the doctor that if there is someone who is dying from COVID, oxygen shall be given. The medicine shall be given. Whatever medicine is authorized shall be given. Proper medical treatment shall be given. That's an obligation of the doctor. It is not an enabling clause. Now, when that obligation is created, under the law of obligations, it is very well established in common law as a very old principle of law, that obligation creates a corresponding right in the beneficiary of that obligation. Because without that right, that obligation cannot be enforced. There will be no accountability in an adversarial system. There has to be someone who is given a right to enforce this obligation. And so every obligation under the law of obligations has a corresponding right vested in the person for whose benefit that obligation is created. Now here this obligation is created in the favor of or for the benefit of the backward classes. And therefore this obligation that reservations must be put in place to remedy inadequate representation of backward classes immediately creates a right in the backward classes to ensure that action is taken by the government under the law of obligations, the general principle of the law of obligations. And that right, because it is in Part 3 of the Constitution, is a fundamental right. So therefore, it is very clear that Article 16(4), the purpose is that there is a right created for adequate representation, a right created for equality of opportunity for those who were denied equality of opportunity, not for those who had it. Issues where people feel they don't have equality of opportunity because of not because of historical discrimination to their class. They have remedies under Article 14. That is, there was no need for Article 16 if that is all that was meant by Article 16. It's already covered in Article 14. Article 16 was created to create rights in favor of those communities and classes that were historically denied opportunities in public employment, and therefore they were given the right to equal opportunity and the right of adequate representation, and a specific obligation on the government to use a particular mechanism, namely reservation. That is the only and most important and most powerful mechanism created by the Constitution, which the state is obliged to use as a medicine, as a vaccine against the virus of inequality of opportunity and lack of adequate representation. And that obligation creates a corresponding right to reservations, which, because we are in Part 3, is a fundamental right to reservation. So it is very clear that we have a vital and very important fundamental right to reservations, and without this fundamental right, Article 14, which is the right to equality, which is part of the basic structure of the Constitution, will be nullified, because of the 15, 16 and 17 deal with very, very serious problems, the most serious problems of inequality that India faces. Discrimination as specified in Article 15, discrimination, public employment as specified in Article 16, and untouchability as specified in Article 17. So Article 14 becomes meaningless unless the particular regimes put in place to tackle the most egregious forms of inequality are also seen as an integral part of Article 14 and are duly implemented, so that we can realize the preambular goal of the right to equality.